for the record. We've read the briefs, we've looked at the record, and we've conferenced the case. So when you begin your argument, just volunteering into what you think we should think about and talk about. So, Ms. Evans, you may begin.
Could we have Judge Bailey just say something first so she appears on my screen?
Oh, hi. Judge Bailey. Nice to meet you guys. That work?
There you are. Thank you.
Okay. You're welcome.
Okay.
Yes, please.
Okay. May it please the court. My name is Jill Evans, and I represent J. Beatte, Jr. We are asking this court to find that the verdict was coerced by the trial court's actions and remarks for two basic reasons. First, almost every factor pointing toward a coercive influence cited in the cases is present in this case, and the error was preserved for review by a timely motion for mistrial, and no earlier objection would have cured the error, and the error was fundamental anyway. And second, the entire verdict was clouded by the coercion. And even if the holdout juror was only concerned with the DCAC factor, the DCAC element was the same as the guilt phase element, and they were combined in one verdict. So if there was doubt as to one, there was doubt as to the other, and the entire verdict must be reversed.
Counsel, what should the judge have done when the presiding juror said what he said?
It's a difficult situation because it was a polling, and the 12th juror indicated that they were undecided, and therefore the verdict wasn't true. And so by that time, the judge already knows the split and knows who the holdout is. So it's a tough situation, but the only thing that the rules allow the judge to do is either declare a mistrial or to ask if further deliberations would be helpful. And really, the judge is supposed to do that to the entire panel, not just singling out one juror, but the juror was the foreman, so he was speaking with the juror who was also the holdout. So it created just an extra coercive environment. So I'm not sure there's anything he could have done besides declare a mistrial, but if anything, he could have asked if further deliberations would have helped before going into quite a long and lengthy discussion.
But counsel, the lengthy discussion seems to come up after the juror says, "I can live with my decision." So the juror has basically, initially he said, yeah, I initially voted yes, it's not my true verdict, but just asking the initial follow-up question that doesn't seem that odd to just say, well, if you disagree, then we can't have a verdict because we have to have a unanimous verdict. And the juror volunteers, well, I can live with my decision. If we had stopped there, would you say there's any problem if the juror has just volunteered, I can live with my decision?
Well, I think at that point, there's certainly doubt that needs to be clarified, at least simply anyway, because he already said that his verdict was one thing by signing the verdict form, and then he's changed his mind. So already you have someone who's shown a susceptibility to wavering or to letting go of his true beliefs. So it's not like, and in Hernandez, I think it was the judge, they actually let it go because the juror said, I have reservations, but I'm going to go with my true verdict. And he said, would you like to talk about this? And he said, no, I'm going to go with my true verdict. And so that was, there's nothing else the judge could have done at that point. But here, that's not what happened. The judge continued to clarify, and during that clarification, he still waffled.
The clarification is helpful to the defendant at this point because he said, I'm going to go with my verdict. I can live with my decision. So the clarification is the judge trying to make sure, I'm not trying to badger you to vote yes. I don't want to convict this defendant if there's any question. That's my hang up. It seemed like the questioning is kind of the opposite of badgering a juror. It's trying to make sure if the juror had said yes, and if he could have stopped, I would have been uncomfortable if the judge had just stopped and said, okay. I mean, as you indicate, he had expressed some reservations. So it seemed like the follow-up questioning was appropriate at that point.
I think a little maybe, but first of all, there's already that problem that he's the singling out the holdout. But the problem here also is that he clarifies several times, and it starts to then become more of a situation like McCrimmon, where he's repeatedly sort of, are you sure it's your true verdict? Are you, I'm paraphrasing obviously, but is it sure, you sure now? And he clarified several times, and at that point, it's when you're singling out that juror, any conversation like that starts to sound like the judge, who knows what happened in trial, is uncomfortable with the one undecided juror, and it's starting to become coercive at that point. Especially when he asks.
Doesn't the juror confirm 3 times that I'm willing to go with my verdict? I mean, he says initially, I can live with my decision. And then he says, I'll just go with what I signed here. And then the third time is, well, if you send it back, we're going to come up with the same verdict.
Well, so it says, oh, sorry.
No, go ahead.
I need to cut you out. He doesn't say it quite that clearly. He says it sort of stuttering, and everyone else said yes, so I'll say yes, and I can live with my decision, and I'll go with what I signed there. I mean, that to me sounds much more like, he's willing to give up his true conviction. And of course, there's other indications that that's exactly what he's doing, especially if you look at the fact that they were hung on the aggravating factor, for example, that there was harm to the victim. And also later in the discussion about the DCAC, again, he's saying, well, by my own convictions, I don't think this is true, but he's just very much wavering throughout the discussion. So much more actually than a lot of the cases indicate that would be enough for coercion alone, especially because he's singled out as the holdout, and he even asks him if further deliberations would be helpful, and he basically answers no twice, and yet the judge still is not giving up on this idea of moving him toward a unanimous verdict, or at least that's
isn't that but that's in the context of the juror saying, I just want to go with my yes vote. And the judge is saying, are you sure? Couldn't we, if you have any doubts, couldn't we have some more deliberations and some more argument to help you?
Well, he's already indicated that he has doubts, and so I think that there's several indications that he was already giving up his true verdict. So it's just too late, instructing, giving a cautionary instruction. By that time, it's the case law would say it's just sort of a hollow gesture at that point, or there's not enough impasse instruction, which also tells him I'm not trying to force your verdict. So because it's a polling case and not a note case, where there's a note given and there's like a, bench conference and a response in instructions and that kind of thing. It's a polling case, and really the judge is supposed to do 2 things, either further deliberations or discharge. And in this case, he went much, much further than that, and created the atmosphere that was coercive.
If there were, sorry if I'm interrupting, you guys can chime in anytime. If this were like a burglary case and one count of burglary and 1 count of assault, and the juror comes back and says, I disagreed with the verdict on assault, would you have a problem with affirming the conviction for burglary and saying the assault conviction cannot stand? Would that be your position, or does the whole thing have to go back?
The whole thing, well, it depends. If there's an assault and a burglary and the judge accepted the verdict on one of them and consulted counsel and everybody agreed there was no question as to the assault, and they accepted a partial verdict and then agreed that they would go back and deliberate on the other count, and they weren't related in any way, so that it wasn't clouding the other count. That's a different situation. This is the same. These are 2 elements of the same offense. The DCAC and the molest both require the same findings. One's inherent in the other.
Is there a requirement? I'm curious. Is there a requirement that the jury be instructed on DCAC?
No, I think that really they could have done it a different way. If he had found molestation beyond a reasonable doubt that it was an intentional or knowing molest of a child under 15, I think that there's a memo decision from your division, even Javier Mora, I believe, that found that there was an inherent, that the DCAC was inherent in the finding of a molestation under the age of 15. So that they really didn't have to submit it to the jury, but they did, and it was all part of the same verdict. It wasn't a separated out verdict. It wasn't a bifurcated proceeding under Rule 19. It wasn't. It was a guilt phase. If it was error, it would have been probably found to be harmless because of that, according to Patterson, cases like that.
Counsel, that raises something that I found confusing. Mm-hmm. I understood that the child molestation was, as you say, inherently a dangerous crime against children. So it's odd to have the jury make that separate determination when it's certainly not a factual determination. It's a legal effect of finding the person guilty of that offense. Given that, can we say that the verdict really wasn't coerced because that finding was superfluous, that it was inherent in the finding of guilt, and that sure the court and the juror had this discussion, which was arguably improper, but it really it was an unnecessary discussion to the validity of the verdict.
The problem is that the discussion shows the doubts that he has about the DCAC finding, which means he has doubts about the underlying molestation because they're both the same thing. So I think they certainly could have gone without that. So
but counsel, at least I read the record, the juror has no problem in finding him guilty of the offense. His issue is with the DCAC designation, which arguably isn't his concern.
Well, our position is, first of all, that it appears that he caves to the pressure and moves into that DCAC conversation, which is sort of a impeachment of his deliberative processes and improper. But let's just say, for the sake of argument, that you don't agree that it appears that what he's doing is just sort of trying to take the pressure off of things to move into this DCAC conversation. Still, at that point, there's no, if you look at that conversation, he's still trying to hold to his true belief that he does not feel that by his own conviction that it's DCAC, and that's what he tells him. And still the judge says, well, would further deliberation help? And then he suggests closing arguments, even though the juror didn't ask for closings and there was no impasse instruction. And so all of that appears to sort of influence him again toward giving up his true belief on the DCAC as well. And it sort of clouds, it's like both cloud each other. Sorry, go ahead.
Let's say the first thing the juror said was, no, that's not my true verdict. And then he says, I agree with the jurors, but I had a problem with the proven. If he's just clear, he says, I agree with guilt on molestation, but I had a problem with proven on the DCAC charge. At that point, with the court saying, do you disagree with what the court did? It starts on page 191 of the pleading. If the whole discussion had just started with, I agree with guilt on molestation, but I had a problem with proven on the dangerous crime against children. Does the court say, would you like additional argument? Further deliberations? Shall we have argument from counsel? Would that be inappropriate for the court?
Are you saying in the beginning of the whole conversation,
yes,
right
so
at the beginning?
The first thing that happens is the juror just says, That's not my true verdict. I agree with the molestation conviction, but I disagree that it's a dangerous crime against children, that was proven. So at that point, can the court say, would further deliberations on that issue be helpful? Would further argument from counsel be helpful?
I think you can ask if further deliberations period would be helpful, not on that issue, but further deliberations period would be helpful. And unless he separates out the verdict with the consultation of counsel and accepts and goes back and repolls and accepts the verdict, then I don't think he can separate it out. But let's just say he does, and he can ask if further deliberations would be helpful. And if the juror says no, then that's it at that point. So it's a mistrial.
And doesn't the juror here say, yes, I would like to hear argument from counsel?
Oh, after 10 minutes of discussion, and
but he initially said no.
And he also actually it wouldn't, and you can't suggest if there's no indication that they're hung, you can't suggest a remedy for an impasse. And here there was no, at this point, there was no note indicating they were hung. It was, they were hung, but the juror was being singled out in a polling process. And so there, I don't know that you can give the impasse instruction, and there wasn't an impasse instruction. And so the judge suggested closing argument. It wasn't requested because it wasn't in response to an impasse instruction. So, yeah, it was just kind of all coercive, part of the coercive environment that was created. I see my time's almost up. I guess I'll reserve the remainder for rebuttal.
Thank you.
Thank you.
Mr. Ball?
Good morning, Your Honors. Are you able to hear me?
Yes.
All right. Well, may it please the court, my name is Casey Ball, Assistant Attorney General here on behalf of the state of Arizona. I think I'd like to start with the harmlessness. That seems to be a lot of the focus of the discussion so far, and the inherent nature of the DCAC offense to the actual offense. I agree with Ms. Evans that the jury did not need to make this finding. It was something that Judge Seif added to the instruction form. He felt that there was some slight difference in the language of knowingly targeted versus just the language of the molestation of a child statute. But the jury didn't need to make that finding.
Well, counsel, what would have happened if the jury had found him guilty of the molestation, but said, no, it's not a dangerous crime against children? I mean, what effect would that have had? That
would be a fairly inconsistent verdict, Your Honor. It would be difficult to judge what would happen there. I think the court would probably have to accept the jury's finding that this wasn't DCAC. And I don't know what he'd sentence it under. The legislature's already designated this offense.
But doesn't that also call into question the molestation conviction, if that's an element of molestation? So I'm the same hypothetical that Judge Howe's given. There's separate verdict forms. They say guilty on molestation, and then they say not proven on DCAC. We could uphold the conviction for molestation if they specifically say you haven't proven. In this case, they're instructed that if the victim's not under age 15, wouldn't that call into question the molestation verdict?
That would be difficult to parse those out, because the definition for DCAC is so specific. It's knowingly targeted against a minor that's 15. The definition for molestation is also knowingly molested a child under the age of 15.
Well, then how do we parse this one out then to say that it's completely harmless?
So I think the difference here is the context and the way the juror is explaining his problem with the dangerousness. When he's explaining his views on dangerous, the DCAC finding, he says, well, as the definition and everything was read, it applies. I just didn't, I don't, by my own conviction, I don't believe that it was. It appears that the juror had a different definition in his mind of what dangerous was, probably the conventional sense that a weapon was used or that there was some serious physical injury accompanying the molestation. And here we don't have any evidence presented at trial that any of that occurred. It was just molestation. And so if the juror is believing that there needs to be something extra to make this quote, dangerous and he doesn't like the definition, then this turns into a juror nullification issue rather than a weight of the evidence problem where an element of the offense isn't met.
Should we have even gotten to the point of knowing specifically what the juror's particular issue was? I mean, is that the problem with not having sent them back as Mr. Beatte says he should have, is that under these conditions in open court, we never should have known what Juror 13's specific issue was. If he'd been sent back and wanted to ask that question, where again, counsel could confer with the judge outside of the hearing of the juror, maybe that would have been appropriate. But should we know that deeply what this particular juror's issue was? Is that part of the problem?
To a degree, though, I think Judge Lambert in the motion for new trial and their discussion they had at that hearing really elicited a key fact here, and that is that the way Judge Sipe was asking the questions was not intending to draw out any specific deliberative thoughts of the juror. These are volunteered thoughts. Judge Sipe is really focused on, what part of this verdict do you have a problem with? He's confused because it's the presiding juror who has presumably understands the instructions, has filled out the verdict, has said it's a unanimous, and is now wavering, and he's trying to clarify, is there a problem with this verdict? But it's the juror.
But if the judge keeps asking and keeps asking and keeps asking, at some point, isn't that inviting some sort of internal, some sort of thought from the juror? When you say, well, it's volunteered, but it's after he's been asked 3, 4, 5, 6 times if this is his verdict. At some point, is there pressure on him to explain to this judge who's not accepting, either, as Judge Catani said, either the first 3 no's or the second 3 yeses aren't being accepted, and he's continuing to be asked questions? Is he inviting that sort of volunteered statement by continuing to ask the juror questions?
Possibly, though. The way he's phrasing his questions, I think, is really crucial. So I'm looking in the transcript where right before the presiding juror explains that he doesn't have a problem with the evidence, the court says, I'm getting the impression you don't want to find the defendant guilty. You have other concerns or other issues that perhaps should have been addressed further by the jury collectively. And you think it will be beneficial to go back and rediscuss these issues, or perhaps even come back tomorrow. You can certainly do so. Nowhere in that question is he asking, what evidence didn't you believe? Was there a credibility issue? He's really just focused on, I'm getting the sense you don't want to find the defendant guilty, which is a question, if anything, skewed in favor of the defendant at this point. He's giving the juror an out. The juror can say yes, he doesn't have to disagree or fight with the judge. And instead of just answering with a simple yes, no, we could deliberate further, or yes, I don't want to find him guilty, the juror elicits this information about, well, actually, all I have a problem with is this last verse where it says proven. So the way Judge Sipe structured the questions was really targeted at just the verdict form itself. It wasn't trying to delve into the typical things you would see during a juror deliberation, like the weight of the evidence or the credibility of the witnesses. That never comes out anywhere. Judge Lambert, in the motion for new trial, as he's talking with the attorneys, mentions he's had a couple of these before and made the statement saying, I can't imagine a court saying, okay, we're done, thank you very much, we're discharging you, without trying to see if they would come to some kind of a resolution, if there was some issue that was hanging out there that a juror number 13, needed more information to make that decision. So Judge Lambert, having been in that position before, understood that Judge Sipe was reasonably confused at the presiding juror's actions and needed some clarification. This court in State v. Hansen approved of discrete questioning when there is a concern with the verdicts. In that, the case is a little different because the jury returned a signed verdict form for guilty on a greater offense, and they had a separate form for the lesser included offense that the presiding juror said he didn't know what to do with, so they marked not guilty. So you had these very inconsistent verdicts where it wasn't clear to the court what the jury intended. Unfortunately, the court didn't see the lesser included form until after they'd sent the jury back for an aggravation phase. And at that point, the trial court felt the only thing it could do was declare mistrial, that it couldn't delve into the deliberative process. Division 2 said it was error for the court to believe that the only remedy was mistrial. It could have made some inquiries to try and clear up confusion, and that it's preferential that if there's any confusion in a verdict form, that you clear that up so that there's not these lingering doubts about what the jury actually believed. So I think this kind of goes back to Judge Catani's initial question, Judge Howe's question about what if they had marked no on the proven element, where you've got inconsistent verdicts, basically. Some discrete inquiry may have been appropriate in that instance under that hypothetical, just to clear up, what seems to be two contrasting views.
I am sympathetic to the view as a legal matter that the DAC is inherent in the finding of guilt in the underlying offense, but it's not how the court presented it to the jury in the verdict form. So, in a sense, even though I think otherwise, as a matter of law, aren't we stuck with how the verdict form broke that out?
Yeah, I mean, we're stuck with the verdict form, though I think, again, going back to some of the context of how the polling process went and what happened afterwards, I think any possible doubt that there was an actual problem with the guilt is assuaged by the presiding juror saying 3 different times that he agrees with the rest of the jurors on guilty, that the facts apply. But then the court focuses the supplemental arguments on the DCAC offense. All of the instruction at that point is only on the DCAC finding. And then after the closing arguments, the judge tells the jury to go back and redeliberate this issue. So by all accounts, everybody had moved on from the guilt determination and they were only focused on this DCAC finding. So
is it problematic though that the court says, and a dangerous crime against a child has a very specific definition, which is included in your instructions? Isn't that kind of telling the juror, just go read the instruction and you'll figure it out? Isn't that pushing maybe a little more than that seems a little coercive? Go read the instruction. It's got the definition. You should be able to figure it out from the instruction, is what I take from that comment.
And in the end, he says, go back and rediscuss that issue and perhaps reread the definition, as in directing them about what they should consider and what they shouldn't. And as a secondary question, if there was a question on the DCAC, and we've been asking today, since they are the same elements, that the judge directed them just to go back to the DCAC. I mean, if the problem that juror number 13 had with the DCAC also affected the underlying guilt verdict, if you're sending them back, can you send them back on just one thing? Or do you send them back to redeliberate the verdict?
So to the first part, go read the definition. The jurors are instructed right from the beginning when they are given the admonition that they have to apply the law whether or not they agree with it. During voir dire, they're asked, can you set aside your personal beliefs and follow the instructions I give you? In the final instructions, they're told, apply the definitions, don't let your personal beliefs contradict the definitions. So it's not inappropriate for the judge to say, follow the definitions if you have
Is it after, if there's a juror nullification verdict, is it appropriate for the judge to come in and say, go read the instruction? Would that be appropriate?
If the jury had come back and acquitted based on jury nullification? Right. Is that what you're saying, Your Honor?
Right.
Probably not at that point, because it's an acquittal. It's not, some confusion with the verdict. But where here it seems like the juror's expressing he just doesn't believe it's a dangerous offense in the common sense of the term. I think it's appropriate to remind the jury.
Where do you get, he's just saying, I don't think that was proven, the DCACF.
So this is...
I'm willing to engage in jury nullification on DCAC. At that point, do you tell him, go read the instruction?
So where the presiding juror says, well, as the definition and everything was read, it applies. So he recognizes that, yes, there was a molestation that occurred. The child was under 15 years old, so the definition applies. It's just that he doesn't, by his own conviction, believe that it was. So he knows the elements are met, but he's got some personal disagreement with the definition. So that's why it turns into a jury nullification issue. As to Judge Bailey's second question, I've forgotten it. It was something along.
Asking about him redirecting the jurors to redeliberate only on that issue when that issue implicates the underlying guilty verdict as well, since we've all agreed that they have very similar or exactly the same elements.
So that's right. I think that this shows that the trial judge really felt that the only issue was the jurors' understanding of the definition and how to apply it. There has to be some deference given to Judge Sipe, who's there in the courtroom reading it. So if the trial judge believed that really the only concern was applying the definition to the finding, then the judge wasn't concerned about the guilt verdict being impeached by the same concerns. I think that's evident in the presiding juror's statement where he says, as the definition and everything was read, it applies. So the juror knows what the evidence is. He knows it applies to the definition. He just doesn't want to do it. And the jury has been instructed since the beginning of trial multiple times that they have to set aside their personal beliefs and apply the law as instructed. So it's appropriate for the court to remind the jury that it's supposed to do its duty and apply the law and not let its personal beliefs get in the way.
Even if they come up with a verdict and he just said, I'm not going to vote guilty I'm not going to vote proven on DCAC. I agree that there's a conviction for child molestation, but I have a firmly held belief that it's not a DCAC. Does the court get to come in and say, you've got to read the instructions?
I mean, at some point, the court has to accept the juror's verdict. Jury nullification isn't a right of the defendant, but it's not something that the state can challenge on appeal or if there's an acquittal. So if it's just the presiding...
Isn't that kind of the problem here? The juror seems to be saying, I don't agree with that allegation.
The way I'm reading it, he personally doesn't believe it's dangerous. And based on the context of the evidence presented, it's probably because there was no indication of a serious physical injury accompanying the molestation. So he's using the common definition rather than applying the instructions.
But is that a problem that we're all kind of surmising something? I mean, yes, that sounds like the logical conclusion, right? And that probably was what was in the judge's mind as well. But the idea that we are trying to get even deeper into this juror's head to make that decision, we don't know with 100% certainty what the juror was thinking. We can all apply logic to what his statements were, but there still may have been something else that he was either hesitant to tell the judge or, felt compelled not to. That's kind of the problem I have too, is that the logical conclusion seems logical to me too. But does that mean it was what the juror was thinking?
So this court has in the past relied on jury statements delving into their mindset. In Rodriguez-Rosario, the juror indicated that he didn't believe the police officers were credible. And that was really the basis of this court reversing those convictions as coerced, because after the juror had said, I don't believe the officers were credible, they were sent back to deliberate. He comes back with a unanimous verdict and then again says, I still don't find them credible, but I went along with it. This court really focused on the fact that he was still focused on the credibility of the officers and that there was some problem with the evidence itself. Here we don't have the same criteria, but this court relied on those statements when deciding whether to affirm or reverse. So this court can use those statements. In a perfect world, we probably wouldn't have gotten this deep into the conversation. The judge probably would have polled the whole jury and asked, would further deliberations help before sending him back in? But to go straight to mistrial just doesn't seem to jive either with the case law or the comments in the impasse instruction rule, which is analogous. We borrow a lot of the impasse cases when we're dealing with a breakdown in the poll because they're similar. And the comment to that rule is that many juries, after reporting to the judge they've reached an impasse in their deliberations, are needlessly discharged and a mistrial declared, even though it might be appropriate and helpful for the judge to offer some assistance in hopes of improving the chances of a verdict. The same analysis applies here where there's a breakdown in the poll. If there's some confusion, especially where it's the presiding juror who's now saying no, there needs to be some follow-up from the trial judge. It can't just skip straight to asking for a mistrial or imposing a mistrial.
Well, Counselor, I don't question the judge's good faith at all. It's a very difficult situation, but it seems like the court just just had too much of a conversation on this? I mean, do you concede that the judge should have perhaps, whether it's reversible or not, that the judge had more of a conversation than he prudently should have?
Yes, yeah, there was probably a longer conversation than necessary in this case. I think that's pretty standard with the case law. The case law says that anytime you engage in these conversations, it's pregnant with the possibility of error, not that it is per se error. Here we have several hallmarks showing that the juror, his independent judgment was not displaced by the judge. He says, "I agree with the."
But what are you saying? At what point did the court start in with too much? What would you, if you're agreeing that the court did too much? At what point was it too much?
I'd probably say that if in a perfect world, after the juror said no, the court probably could have asked a discrete question. Even the question he asked, "Can you explain that to me?" Just to understand, what the juror is saying. When the presiding juror says, "I don't believe part of the evidence," at that point, if I was the judge, I would say to the jury as a whole, it appears we don't have a unanimous verdict. Show of hands, how many of you feel that further deliberations would be useful? Poll the whole jury so that it's not, singling out the one juror, and then send them back. If a few of them respond that further deliberations would be useful. I think it was McCutcheon, 1989 case from the Arizona Supreme Court, where 3 jurors said that they felt further deliberations would be useful, and the judge sends them back and they deliberate further. So if there's an indication that further deliberations would be useful, then he'd send them back and go from there. But just because he has a conversation doesn't necessarily make it reversible error, especially where the juror was very comfortable clarifying his position to the judge and pushing back on the judge's suggestion that he didn't want to vote guilty. He pushed back later in the evening when the jury as a whole, it's unclear who couldn't decide on the aggravating factor, but the jury as a whole couldn't agree on the aggravating factor, and it's later in the evening and they're still willing to tell the judge that they can't reach a unanimous decision on that factor. I see that I'm out of time. Are there any further questions, Your Honor?
No.
No, thank you.
Thank you.
Right.
Thank you.
Thank you,
Thank you, Your
Mr.
Honors.
Ball. Ms. Evans, rebuttal?
One thing about whether or not the underlying charge implicates the same element as the DCAC, it's not just whether or not he's under 15, but whether or not, or she, the victim, but whether or not the conduct implicates DCAC because it was targeted at the victim, which is the same thing as intentionally or knowingly causing a molest. So the juror actually indicates that he has some problems with the proof. He's not convinced beyond reasonable doubt, perhaps, about the molest. He says he has trouble with some of the evidence. Maybe he's not able to articulate and certainly shouldn't be asked to.
I'm looking at page 190, though, where the juror specifically says, "I agree with the jurors. I had a problem with the proven on it." Isn't that a pretty clear indication that I agree with the verdict on molestation? What follows from proven only goes to the DCAC. So I don't read that as the juror expressing any misgivings about the molestation conviction.
I mean, that's fair enough. I think at that point, our position is that he's already trying to find a way out. But if you don't agree with that and he's saying that, it still doesn't save this case from a coercive atmosphere and a coerced verdict, because they go on to discuss the DCAC, and DCAC is part of the whole verdict, and so you can't parcel it out under a general verdict. Also, you did note that at the end of the discussion, near the end where they send them back, where he sends them back to redeliberate, he tells them, there's a very specific definition for DCAC. You read it, it's very clear. He also includes in the instruction, the final instruction, that you must follow the law. So even more sort of, coercive, even though he also says, to be fair, he says, don't give up on your true beliefs. You must also follow the law. At that point, it's just an inference that he wants him, that being undecided about that is just not okay, and that he wants him to go ahead and give up on his true verdict. And then the verdict, of course, comes back 4 minutes later without any new information being provided in closing arguments. So if you go through the case law, you can just point out or pick out just about 10 things that were done that created the coercive atmosphere. And I think we pretty much covered them in the briefs. But in this case, the totality of the circumstances deprived him of his right to unanimous verdict, which he had a right to on all elements. Nullification, that's the power of the jury. Inconsistent verdicts are allowed. So with that, we request that you reverse the verdict because Mr. Beatte was deprived of his right to a fair and impartial verdict by a unanimous jury. Thank you. Do you have any? I'd be happy to answer any further questions if I have time. I'm not sure what the time limit is, but.
Thank you, counsel. We appreciate your argument, and I apologize for mispronouncing the defendant's name as Mr. Beatte. We appreciate your argument today, and we'll take this matter under advisement and we'll issue a decision in due course, and we stand adjourned. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor.